Agora com o painel Resolving Corporate Bribery Cases, Targets, Settlements and Penalties. Eu tenho algumas, não recomendações, mas a forma como o professor vai querer conduzir os trabalhos agora do final da nossa manhã. Ele pede que as pessoas sentem um pouco mais à frente, tanto quanto possível, porque a ideia é que a gente tenha uma sessão mais interativa, com a participação de todos e que a gente seja informal na nossa comunicação, na questão da linguagem, da transição inglês-português, para que a gente se sinta à vontade para contribuir também mostrando a ele qual é a realidade brasileira e como ela se comunica com os panoramas que ele vai trazer de outros países e, sobretudo, da realidade norte-americana. Outra ideia que ele deu para essa sessão agora da nossa manhã é de que, tanto quanto possível, nós não utilizemos os nossos telefones celulares. É claro que cada um fica à vontade para usar o seu notebook e o seu celular, se não concordar com esse encaminhamento da discussão. Mas ele considera que é mais produtivo se a gente se concentrar, até porque a gente vai ter que, de uma certa forma, vencer a barreira de uma certa timidez inicial de se comunicar num auditório grande, trazendo experiências em assuntos que são tão complexos, e, ao mesmo tempo, vencer uma certa barreira da linguagem e da comunicação. Então, se vocês puderem se engajar no espírito de ter uma sessão participativa, eu acho que vai ser muito produtivo para nós todos. Seguindo mais ou menos o protocolo que houve, ele também fez um outro pedido para mim breve, vou ser breve nisso. Existe um certo cronograma e um certo volume de leituras que ele entendeu como pertinentes para o que a gente vai conversar hoje. As leituras que ele separou para esse momento da manhã de hoje, diferentemente das leituras que são objeto da manhã do dia seguinte, são leituras que tratam mais dos arranjos institucionais do sistema de combate à corrupção. Então, aí vai entrar leniência, vai entrar as penas que estão na nossa lei. Então, por exemplo, ele pode usar uma expressão como debarment, que seria a nossa pena de idoneidade. Às vezes a gente dispensa a tradução e fica um pouco empacado nessas expressões mais técnicas. Ele pediu que, tanto quanto possível, eu pudesse, do que eu lembrar, trazer para vocês. O objeto do que vai ser abordado aqui é responsabilidade das corporações versus responsabilidade dos indivíduos, como a gente chega em situações e pontos ideais dentro dessas duas possibilidades, e essas figuras todas que perpassam esse sistema de anticorrupção, que são a leniência e todos esses itens que estão na nossa legislação federal, que já foram, em parte, até abordados na sessão de ontem. Bom, agora voltando ao protocolo que foi da mesa científica com o professor na manhã de ontem, vou dirigir algumas palavras a ele em inglês, basicamente transpondo o que a gente conversou e combinou um pouco aqui agora. Professor Matthew, is never enough to say how our school is honored by your presence. It's such a pleasure to have you here. And yesterday you brought us some core notions on what kind of problems corruption causes in economies, in regulation, in combating poverty. You told us that it undermines talents, it creates false competitive advantages, and a lot of notions that are really important. But above all, what captured my attention is that you said that none of this have to do with the lack of the state, with the absence of the state. On the contrary, you told us that above all, the way out of this corruption that we see, the systemic corruption, depends on politics and depends on democracy. And I think this is really relevant, and it connects with the previous conference we had today of Judge Neibello. And it's pretty remarkable that you told us yesterday that it's not a moral or a cultural crusade. It really has to do with bringing the state back in and bringing the institutional analysis for this whole panorama that we are dealing today. And so I told everybody about the readings and about the institutional arrangements that you were going to address today, and how important it is to everyone feel comfortable and informal in our communication, so we can have a very productive morning. Okay, thank you for being here once again.
Great, thank you so much. Thank you for those kind words. Thank you everybody for being here. I can't express enough how grateful I am and how excited I am about this opportunity. So today's session and the sessions, at least with me, tomorrow and Friday, are going to be a little bit different from yesterday's session. Yesterday's session was more in the order of a traditional, long, I fear, boring speech where I'm just talking at you. My original plan for these next 3 sessions, today, tomorrow, and Friday, would be something on the order of more like a discussion seminar, an exchange. When I made that plan, I was under the impression that this was going to be a smaller group than it's turned out to be. So while I'm delighted that we have a much larger set of people who are interested in the conversation, I recognize it may be a little bit more challenging to have that same kind of interactive discussion, but I'm hoping we can all do our best. I will try not to talk for too long, to leave plenty of opportunity for exchange. And really what I just want to do in these sessions is to start out the session by putting on the table some important issues or controversies related to the fight against corruption that I gather have some relevance today in Brazil, to say a little bit about the debates over those topics in the academic literature or in the international discussion, and then I hope through that to provoke a conversation among all of you, all of us, on that topic. I should also say that I have pledged the organizers to keep the conference running on time by ending at 12 p.m. as originally scheduled, today, tomorrow, and Friday, no matter what time we start. So that means if the morning sessions run long, we're just going to cut time out of our session. If that creates an incentive for you all to keep the morning speakers moving quickly or to talk for even longer, I leave that to you. That was a joke, by the way. No one's laughing at my joke. This is like a bad start if you're trying to, never mind. I say I'm trying to warm the crowd up here a little bit. We're a little more informal today. So today we've got about an hour and 10 minutes. I'm going to, first of all, encourage the people who are still not sitting close up that there are plenty of seats up, especially in this first row here. Lots and lots of first row seats, so come on down, everybody. The topic I want to talk about today, or really that I want to get us all talking about today to one another, is one that I know from talking to people here has a lot of significance right now in discussions in Brazil, and that has to do with the appropriate strategies for dealing with corporate bribery cases. By corporate bribery cases, I mean cases that involve corporate entities, companies whose employees or officials are accused of paying bribes. What legal tools and techniques are most appropriate for prosecutors to use when dealing with those sorts of cases, and what sorts of legal institutions would be most appropriate. And I want to focus in particular, actually, there were some reading materials that were distributed. I want to get a sense of, so how many of you got the reading materials in advance for this session? Ooh, not as many as I'd hoped. How many of you read the reading materials in advance for this session? Okay, not great. As a professor, not thrilled that people aren't doing the readings, which is going to make this a little bit harder because I had kind of organized my discussion on the presumption that everyone would have read the materials in advance. So if you don't have the materials for tomorrow and Friday and you want to attend these sessions, please make sure you have them and you read them. Okay, that's useful information to have as I try to adjust my strategy for this morning. Okay, so I want to talk about 3 main topics, or put 3 main topics on the table, all of which are covered in much more detail in the readings that were circulated. The first issue has to do with the appropriateness of settling bribery cases against corporations as opposed to litigating those cases to final judgment in court. Or to put a slightly different question, the one that's very closely related, is when it's appropriate to use settlements that do not require a guilty plea or criminal conviction. So this is a very important issue in corporate bribery cases, a very important controversy not only in the United States but in many other countries, and I gather in Brazil as well. So I want to say a little bit, provoke a little bit of a conversation about when or under what conditions it's appropriate to resolve corporate bribery cases through settlement rather than through other means. The second issue, which is very closely related but not exactly the same, is to what extent should enforcement authorities focus on liability of the companies themselves And to what extent should they focus on liability of the individual actors who are responsible for paying the bribes? Obviously, both are important. I don't think there's anybody out there who says it should be exclusively corporate liability or exclusively individual liability, but there are significant and ongoing debates about the relative importance of corporate versus individual liability. Some who really want to put the focus on establishing corporate liability, fining or criminally convicting corporations, with individual liability, especially for lower level corporate employees, secondary concern. There are others who believe that approach is a mistake, and who think the main focus in fighting corporate bribery should be on putting people in jail, putting in jail the individuals, not just the high-level executives, but the individual line employees who are responsible for paying bribes. So that's the second issue. The first issue you can think of as the settlement versus litigation controversy. The second issue is the corporate liability versus individual liability controversy. Third issue that I hope we can discuss a little bit has to do with the appropriate sanctions for corporations, and in particular, whether or under what conditions it's appropriate to prohibit those corporations that have been found guilty of corruption or other integrity-related offenses from doing business with the government in the future. What we refer to in English as debarment. I gather there's a Portuguese, what's the Portuguese phrase that you'd use for debarment here? You say it on the mic so they can hear.
Eu traduzi como pena de inidoneidade. Fica ruim, Luana? O que você acha? Banimento, né?
All right. So there's a debate about the appropriate use of debarment penalties. This one's also related to the settlement versus litigation issue, because one of the reasons, as I'm going to discuss in a moment, that some corporate bribery cases are sometimes resolved through settlement is because both the defendant company, obviously, but also the prosecuting authorities would like to avoid debarment as a consequence, sometimes an automatic consequence, at least in some countries, of a conviction for a corruption-related offense. If there's time, and again there may not be, given that we're starting a little bit late and we're going to end on time, there's a fourth issue that was touched on briefly in the readings that might be worth some conversation, and that has to do with the issue of victim compensation. To what extent resolutions of corporate bribery cases ought to involve some kind of compensation, recompense, restitution, what have you, to the individuals or entities that we believe are the true victims of corruption schemes. So we may or may not get there, but now let me, again, just say a few words by way of introduction of each of these three topics to give you a sense of what the lines of debate are. And I may allude a little bit to the Brazilian case, but I'm actually mostly going to speak either generally or about the debate in the United States or the international community. I don't know the Brazilian context well enough to say very much confidently about it, and I hope that in our discussion you all will intervene and give your sense of your perspective on these issues in the Brazilian context. But first, the issue of the appropriate use of settlement mechanisms, resolutions that don't involve litigation or sometimes don't even involve conviction in corporate bribery cases. In the United States, in the corruption context, you see this most frequently in the foreign bribery setting. There are domestic corporate bribery scandals in the United States from time to time, but not as many. It's not as central. So in the United States, when the issue comes up, how should we resolve charges against corporations that have bribed public officials? It usually involves foreign corrupt public officials under a United States statute called the Foreign Corrupt Practices Act, or FCPA. The overwhelming majority of FCPA actions brought against corporations are resolved by settlement. They never go to trial. I think there may be in its entire history maybe one FCPA case against a corporation that actually proceeded to trial. Of the cases, FCPA cases that are resolved by settlement, most of them, not an overwhelming majority, but a solid majority, I believe, I haven't checked the statistics recently, are resolved through these settlement mechanisms that do not involve a criminal conviction, that do not involve a guilty plea. And so, again, one way you can settle criminal charges is for the defendant to plead guilty and accept a sentence, usually a lower sentence, in exchange for the guilty plea. But in some contexts, especially the corporate criminal context, there are these settlement mechanisms that are widely used that don't even require the defendant to plead guilty, although they do involve, interestingly, a requirement that the defendant acknowledge wrongdoing. It seems like a weird technical distinction, but it turns out a lot of bad things can happen to you as a company if you have a criminal conviction, and there's this interest in avoiding them. In the United States, these mechanisms are called deferred prosecution agreements, DPAs, or non-prosecution agreements, NPAs. They have different names in different countries, but again, the basic idea is that the government is going to file charges against a company for paying bribes to a foreign official. The prosecutors and the defendant agree that, at least in the case of the deferred prosecution agreement, the charges will be filed, but the government won't pursue the prosecution for some period of time. And if the company complies by the terms of the agreement, the government will drop the charges at the end of that period. Non-prosecution agreements are similar, except that the government just agrees that in exchange for the company engaging in certain behaviors or agreeing to certain things, they won't prosecute. DPAs, NPAs, there are some technical differences, but for our purposes, they're the same. All right, so that's the way most FCPA cases are resolved against corporations are resolved in the United States. There are some controversies about these mechanisms, and so I want to say a little bit about what the perceived advantages of settling corporate bribery cases, or frankly any cases, are thought to be, and then what some of the most important criticisms of this practice are. So the most important prominent argument in favor of settlement as opposed to litigation is that it's more efficient and avoids risk. So in any given litigation system, whether a criminal case, a civil case, or what have you, you have two parties with divergent interests, and the outcome, if they go to trial, is unknown. It doesn't mean it's a 50-50 coin flip, right? One side could believe it's got an 80% chance of winning versus a 20% chance of winning, but the outcome is unknown. And litigation is costly, right? It's expensive. It consumes time, it consumes money, it consumes other resources, it consumes emotional energy, at least if people are involved. So if you have two opposed parties that face a risky and costly situation, it is usually the case that if they can form common expectations about the likely range of options that might occur if they proceed to litigation, they would both be better off if they can settle the case. Indeed, although this is counterintuitive to some people, if you discount the idea that litigation may have public benefits that accrue to parties other than the parties in litigation themselves, we would want all cases to settle. We would never actually want to go to trial. Trials are a waste, right? There's an analogy to international negotiations and war. Right? If two countries dispute a certain piece of territory, right, they can resolve this through negotiations, they can go to war. If they can form common expectations about what's likely to happen in war, then at least ahead of time, they're better off negotiating a settlement than launching the missiles. Right? So too in litigation. This is a very powerful argument for settlement in all contexts, civil context, criminal context, what have you. Litigation is risky and costly. Both sides recognize this. They can both make themselves better off, at least in expectation, without knowing the ultimate outcome, if they can settle. Now, specifically in the context of criminal enforcement, especially perhaps enforcement against white-collar crimes like corporate bribery, settlement also substantially expands prosecutorial capacity. Not everyone thinks this is a good thing, but from the perspective of prosecutors, this is a very good thing. Because if you are the United States Department of Justice FCPA unit, and you've got a relatively small number of attorneys, and you've got dozens and dozens of corporate targets that you believe have paid bribes, and they all are quite affluent and can hire excellent attorneys to defend themselves, you might not have the resources to go to trial against all of them. You couldn't credibly threaten to go to trial against 20 corporate defendants in any given year. You could maybe credibly threaten to go to trial against one or two of them. But the corporate defendants face a kind of collective action problem. You can try to negotiate settlements with all of them, and if all of them recognize that most of the other corporations are likely to settle, then each individual corporation recognizes that if it refuses to settle, it may wind up at trial, which is an undesirable outcome. So the existence of settlement as a mechanism is also a way for prosecutors to leverage their relatively limited resources to resolve a larger number of cases against a larger number of defendants. Related to that point, the settlement mechanism gives prosecutors more levers that they can use to create incentives for potential corporate defendants to, for example, disclose violations that have been detected internally and to cooperate with ongoing investigations. If prosecutors' hands are tied, if they need to go to trial every time they have evidence that wrongdoing has occurred, and if they have very little flexibility to offer a better deal for corporations that cooperate or that come forward with useful information, then prosecutors will be deprived of that incentive tool that they can use to try to get information from companies. And that kind of tool is one of the most important ones that U.S. prosecutors, for example, use to get information on foreign bribery cases. The U.S. government has made it very clear, and indeed within the last year has made even more clear, that if a corporation that discovers its employees have potentially violated the FCPA come to the government and acknowledge potential wrongdoing and cooperate with an investigation, the U.S. government will, in some cases, simply decline to prosecute altogether, and in other cases will be willing to reach a settlement with the company on relatively favorable terms. That's certainly good from the defendant's perspective, and it may be quite good from the prosecutor's perspective as well. One other advantage that's specific to DPAs, NPAs, and other sorts of settlement mechanisms that don't require a guilty plea or criminal conviction is that they can avoid the collateral consequences of a criminal conviction, which may include debarment. Again, I'm going to talk about that in a moment, but can also include significant reputational damage to the firm, which the firm may want to avoid, and which the prosecutors may also want to avoid if they think that that collateral damage might injure innocent third parties. All right. So those are all the reasons that many people, including many people in the United States government, and I'll confess myself as well, are enthusiastic about the use of settlements as a tool to resolve white-collar crime cases generally and corporate bribery cases in particular. But there are a number of important criticisms of settlements, as well as some arguments why this mechanism, even if it works well in the U.S. context, may not export very well to other contexts. So I want to flag some of these before we move on. One concern is not specific to the bribery context and might even not be as apt in the bribery context, but I want to mention it because it does get discussed with some frequency. And that's that I said before that if we ignore the benefits to the general public other than the parties to the litigation themselves, we would want all cases to settle, but maybe we shouldn't ignore the more general benefits to the public at large from litigation. Those might be important. One of them is simply the function of clarifying the law. So if a case is litigated to a final judgment, you will have a court issue a ruling, often a ruling on contested issues of law, what the law means, for example, and that clarification may be helpful to other parties in the world to understand what the law requires, what the law forbids or permits. And it's an interesting fact here just to note that the U.S. Foreign Corrupt Practices Act contains a number of important ambiguities. Who counts as a foreign official? What counts as something of value? What counts as for purposes of obtaining or retaining business? What exactly is the scope of the statute's jurisdictional provisions that are still unresolved? 40 years after the statute was enacted, more than 40 years after the statute was enacted, these are the kinds of issues that in other contexts we would expect would get clarified over time as courts issue rulings on the meaning of the FCPA, and maybe some of the cases even go up to the Supreme Court. One of the reasons that has not happened in the FCPA context is that the overwhelming number of these cases are brought against corporations and settled, so the cases don't get litigated. Now, some people are not very bothered by this. Some people think this is perfectly fine, but other people say this is one of the costs of resolving cases overwhelmingly by settlement, is that we don't get the clarifying function of judicial resolution, especially appellate judicial review, performed. Second concern, and this is one for those of you who did the reading know has figured very prominently in some of the critiques of the settlement mechanism coming from the anti-corruption community, is the concern that they can be too lenient, that companies will be able to negotiate excessively favorable deals with prosecutors. In extreme cases, though I think this is less true in the United States, there's this concern of collusive deals between prosecutors and corporate defendants that let the companies off with a slap on the wrist, or that even if prosecutors are acting in good faith, prosecutors are very busy, they want to resolve cases quickly, they may have excessively strong incentives to settle cases quickly and for not very much money and without requiring more severe criminal penalties or charges against individuals, just to clear the cases, just to process the cases through. So you see a criticism that runs the use of settlements, especially DPAs and NPAs, to deal with foreign bribery under the FCPA or other statutes, allows corporations to treat the costs of foreign bribery simply as a cost of doing business, and they know every once in a while something will go wrong, but then they'll just reach a settlement with the Department of Justice and pay a few $1 million and move on. So there is that criticism coming from the anti-corruption community that would like more aggressive enforcement of statutes like the FCPA. Interestingly, you also see a criticism of the excessive use of settlements coming from the defense bar and the Chamber of Commerce and some of their allies in the United States that claim that the use of settlements is unfair to corporations, that because the United States government has so much leverage in these negotiations with corporations, because a corporation can't afford to be indicted, let alone risk a conviction, it could destroy the company completely, or so the argument goes, that the settlement mechanism allows the Department of Justice to extract fines and other penalties from companies that probably didn't even violate the law at all, and where the government would not be able to prove its case if it had to go to court, but because the government has the settlement mechanism available to it, it can get settlements in cases where actually it shouldn't be able to hold these companies liable for violations at all. So you get criticisms of the settlement mechanism both from people who think that FCPA enforcement is too aggressive against corporations and from those who believe that FCPA enforcement is not aggressive enough against corporations. So those are some of the main concerns about the settlement mechanism. There are also some broader questions that have started to arise, especially now that countries besides the United States have started in the corporate bribery context or elsewhere to experiment with broader use of similar sorts of mechanisms. So the US has been very influential here, but many countries have decided they don't want to just import the US model wholesale. They want to make important changes to it. Additionally, some have noted that the US system only works because of certain background conditions, legal or institutional conditions, that might not exist in other countries and may make the export of the US settlement model not work in other countries, at least not unless those other countries also make other significant reforms to their criminal procedure and corporate criminal law systems. So one point of debate has to do with the appropriate judicial role in these settlements. The United States is at one extreme, where the judicial role in settlements of these cases is minimal. Nominally, a judge has to approve a plea bargain or a DPA, but in practice, this, in almost all cases, is little more than a rubber stamp. Pretty much all of the action is the negotiation between the prosecutors and the defense attorneys, and once they reach an agreement, in all but the most exceptional cases, the judge will simply approve that without that much in-depth inquiry. The United Kingdom took a very different approach in its recent reforms to its corporate criminal law. It created a more expansive mechanism for something like the US DPA, but has a much more involved judicial role in supervising the entire process and making a preliminary determination that that sort of corporate settlement might be appropriate in this case, and in approving any final settlement that is reached. Other countries, like Canada and Australia, seem to be charting a kind of middle course where there's not the same degree of judicial authorization of and supervision of the settlement negotiations, but there is a more extensive judicial role in approval of any final settlement as in the public interest and the interests of justice than you see in the United States. So that's one issue that we see, what's the right judicial role? Another issue, as I just mentioned, is what are some of the other background conditions that allow this mechanism to work very well in the United States that may or may not exist elsewhere? Some have suggested that you can't separate the apparent effectiveness of the U.S. deployment of settlement mechanisms in corporate bribery cases without also recognizing a background in which the U.S. has very broad principles of corporate criminal liability and a credible threat, even if one that's hardly ever used, to take the corporation to court and potentially criminally convict it. In the United States, corporations are criminally liable for the acts of their officials or employees, even if senior management did not approve of or even know of the wrongful conduct. Which means corporations know that if an employee has gotten caught red-handed paying bribes, they're on the hook. They're not going to be able to get out of this by saying, but it was against corporate policy, but management didn't know. And that gives the prosecutors a great deal of leverage at the beginning of the settlement negotiations. The other thing is, corporations know that they don't really have an option to delay and delay and delay and to keep things going forever, that if they refuse to reach a settlement with the DOJ, they may be in real trouble and face significant penalties in the relatively short term. Whereas in other countries that have thought about adopting this mechanism, one concern that critics have raised is that what incentive do these companies have to settle in the first place? If they refuse to settle, the enforcement authorities still don't have an adequate stick, is the metaphor. The carrot of settlement doesn't mean anything if you don't have the stick, the threat of litigation. So I'm torn as to whether I want to turn immediately to say some words of summary about the corporate versus individual case or the debarment case. I think actually it will be better for me to stop here, and maybe we'll naturally lead into some of these other topics or not, but I'm worried about consuming all of our time with just talking at you, since I've already laid out what I see as the more general debate in the United States and internationally about the appropriate use of settlement in corporate bribery cases. I would love now to hear from some of you with your perspectives, especially, though not necessarily exclusively, your view about the appropriate use of these mechanisms in the Brazilian context. Again, I'm not a Brazil expert, so I'm hesitant to say much about this, but I know that the use of so-called leniency agreements authorized by your Clean Companies Act have played an important role in the car wash investigation and other recent corruption cases. I know that Luana wrote a piece on my blog that was in the reading for all of you who had an opportunity to do this, that offered her perspective, at least then when she was a student. Her perspective might be different now as a public prosecutor on the use of these mechanisms. So now I'm going to shut up for a little while, except that I might run around with a microphone and answer questions or engage with people. I would like to hear what you all have to say about whether or how settlements are an appropriate method of resolving corporate bribery cases in the Brazilian context or generally.
Quem quer começar, gente? Alguém tem uma pergunta, comentário? Ana Paula. Tem um microfone sem fio para levar a tela, senão eu levo.
So I'm going to just, does this work? Hello?
Microfone, se
Yes?
tem uns 2 ou 3 para circular.
What? Oh no, but I wanted to make it a little bit more informal.
Transmissão
So I'm going to
funciona.
come down here, and I'll try not to trip over your charging cord. Because if I'm up there, this still feels like a lecture. And as I said, I lectured yesterday, and I probably talked for too long, but really, the value of my presence here, if there's any, is to stimulate a conversation among all of you. I don't think it's every day that we get this collection of Brazilian legal, prosecutorial, and judicial talent in one room, people so interested in anti-corruption. So what I'm really trying to do with my remarks is to get the discussion going. I'm sure people have thoughts about this. It can't be that in this room people haven't thought about the issue of what's the appropriate role of settlements in corporate bribery cases. Some people must think this is like a really good idea, and some people must be concerned about it. Do people have any thoughts? People just shut. Yeah, Bruno, kick us off. Oh wait, there's a microphone coming around, but I'll just hand you this one so we don't delay.
Professor, you mentioned that the outcome is unknown. in this kind of cases. But I think that we should consider how unknown is this outcome. So what's the dose of uncertainty that is involved in those kinds of issues? And do you think that there's any difference from the American perspective and the Brazilian perspective in terms of how discretionary is the imposition of sanctions and how it affects the likelihood of a settlement and the terms of the settlement?
Yeah, here. There's another microphone somewhere.
Thanks. Just let me add on Bruno. Does it make sense to push for a settlement system when we have an impunity context? I mean, as you said, in Brazil, we still have the feeling of impunity. Obviously, it changed a lot with Lava Jato and Cow Watch operation. But still, it doesn't crash on companies. So I'm a lawyer, and I'm working with compliance programs and stuff. And from time to time, we have to handle with people, well, I did pay. And sometimes I say, well, let's push for a settlement. That makes more sense to me. But they say, listen, what's my incentive? Because I don't have this stick, as you said. I don't feel like this stick is going to handle me. So I just want to, bring this on. And, how does it make sense to push for a settlement system when we don't have, when we feel like impunity in the context?
Luana, you want to?
Yeah, in the same line, I'm worried about the deterrence effect from punishing corrupt companies only by fines. Because if we settle, if we go through an agreement, the punishment will be fines, right? But the punishment costs normally are lower than the expected benefits. The expected benefits from crimes such as corruption are very high, but on the other hand, the expected punishment is very low in Brazil. This expected punishment, as you know, is an equation that includes the probability of getting caught, the probability of being punished, versus the amount of sanction. The amount of a fine can be high, but in Brazil, the expected, the probability of being caught is very low. So how can we solve this equation? How can we, only through fines, how can we deter companies from doing this kind of crimes if the probability of getting caught is so low and the expected benefits is so high?
So, I have a question I want to put back to you, but I want to make sure we get more voices here, so please.
So, Professor, I think we have a lack of leverage in case of bribery corporations. Why? The Brazilian legislation doesn't allow criminal liability of corporations in terms of a bribe and corruption, only in environmental cases. So our own legislation is a kind of limit for us, a boundary for us. If we change the criminal legislation, allowing or giving more leverage for the, doesn't matter if the prosecution's office or even the judicial power, I think this maybe can be the starting point. Because when you see the FCPA, the NPAs and the DPAs, prosecutors in the U.S. they have more leverage because they can act right now. They don't need to wait for something else. This is like something that afflicts us, but is a reality in Brazil.
I think the big question is how to balance. We want to settle because this is a big tool to fight corruption. But then on the other hand, as she said, we want to defer crime. So if we settle too low, we are not deferring crime. And sometimes here, we're not putting all the benefits in the settlement's value, just looking at fines, as she said. So that's something I think we all want your input about how to balance this equation. How do we judge what is to be too lenient, as you said in your speech, but on the other hand, and at the same time, not allow crimes to go on. We don't have a big stick in Brazil, so this balance point is very tough for us to see.
Oh, yeah, please.
Just in addition to what was already asked, my question is, it seems to me that in the States, when a corporate gets caught on bribery, they are ashamed. And this is one of the reasons the settlement agreements, they go so well. Of course, our law is different, but we are starting to also do this kind of arrangements. But it seems to me that our feeling, the corporate feelings in Brazil are not of shame when they get caught. So to what point this social feeling interferes also in the success or not of the settlement agreements?
Can you just say a little bit, I want to make sure I understand the point. Can you say a little bit more about how the feeling of shame would make the settlement? I don't quite, can you say a little bit more?
I think when the corporate in Brazil is caught paying bribery, they don't care. I think it's better than to go to trial, because they know it's going to last many years. People will forget about it. Eventually, they'll get away with it. So why should I do a settlement agreement if I can go to court and have millions of appeals and now push for 10 years this case?
I see. So it's a similar point that your colleague was making, but in a different way. It's the idea that settlement only works if the prosecutors have sufficient leverage, if the companies are scared enough about going to trial. And one way they could be scared is if they go to trial, the actual legal penalties will be very, very high. But another reason they could be scared is if they go to trial and they're convicted, it will be very bad for their corporate reputation. And I take it your point is, in Brazil, if I understand you correctly, in Brazil, too many companies are not worried about what going to trial, and therefore the settlement mechanism doesn't really help because the prosecutors don't have sufficient leverage in most cases. Is that the basic point?
I think so, that's it.
All right, I think I could let...
So I just want to add a point that in Brazilian law, we have a different point in our legislation that the company needs to add evidence, to show evidence of other crimes in order to sign an agreement. It's not enough to pay the fines. They have to show evidence, and it allows to increase the investigation. So just to add that we take this in consideration, how much of evidence we receive and how it will, and which is the potential to increase the investigation with this evidence. So and this amount of evidence will make us analyze of which will be the penalty that the company will receive. But the idea is not to take the company to bankruptcy, but just clean the company and make the company continue to work, but change the way that it works and make it improve compliance programs and other things. And we believe that today we have other scenario because international, because other countries see what's happening. For example, in Brazil, and some companies that paid bribes in Brazil, they are also responsible in other countries. So this point also stimulates the companies to plead guilty and to look for some settlements.
Great. I wanted to let me get in a couple other comments here, and then I want to pick up on something that several of you have said that I think naturally leads into the other topics I wanted to discuss. But let me get you.
Pessoal, já que temos pessoas de vários lugares, se vocês puderem se identificar, acho que fica bom para a gente entender as perspectivas. Por favor.
Okay, I didn't know what you just said, but I hope it was something nice. Oh, good idea.
I don't know if you prefer that I make my question after, because it has nothing to do with settlement, but with debarment. And okay.
Actually, no, I'm glad you brought that up, because I want to, several of you have said something that actually does tie into a couple of the other topics I wanted to discuss, and that's this concern that I'm sorry, was your...
No, keep
yeah,
going.
And that's this concern that the leverage that Brazilian prosecutors have may not be sufficient. But I also want to pick up on something, Luana, that you said that I think is useful both in its own right and to connect to these other 2 points I said in my opening remarks I wanted to touch on. So Luana, I get to pretend I'm your professor again, which is kind of fun. You said, well, the real problem is that the companies are, there's not sufficient deterrence because they only pay fines. There's no other penalty. So there are a couple different ways one might respond to that. One natural response from someone who likes the settlement mechanism would be to say, if the problem is insufficient deterrence because the fines are too low, you should raise the fines. Right? One thing you could just say is, well, look, if the problem is that Brazilian law, let's say, again, I don't know, but let's just assume for the moment that the Brazilian law does not provide sufficient financial penalties for acts of corporate bribery, and that means in the settlement negotiations the prosecutors don't have enough leverage to impose high enough fines to deter, then the solution would not be to limit the settlement mechanism, but rather to simply up the financial penalties. But Luana, your comment suggested that even higher fines wouldn't be enough to deter, that you should have some other kind of penalty, some other threatened punishment that would have a greater deterrent effect than fines imposed on the corporate treasury. And there are 2 in particular that often come up in these discussions, including by those who critique the use, or they would say the overuse, of the settlement mechanism. One, and that was the one that you just mentioned, so I do want to make sure I get back to you in a moment, is debarment. And another is sanctions, including potentially jail time, against the individual corporate agents, especially high-level executives, but even lower-level employees who are responsible for paying the bribes. So on the issue of individual liability, the claim is that the individuals don't care if the corporation is fined. Even the corporation only sort of cares that the corporation is fined. It's just money. Money comes, money goes, but when people go to jail, that's when folks take notice. So there are those who say that one of the problems with the settlement regime in the United States right now is that not enough individuals go to jail, and that we're not really going to deter corporate crime, including foreign bribery, until individuals go to jail. So that's one argument. There are arguments on the other side, too, that I hope we get a chance to talk about. But then there's the debarment remedy, right? So the debarment remedy says that, look, if a corporation has engaged in this sort of dishonest, unlawful activity, it should be prohibited from doing business with the government for a period of time, or at least its ability to do business with the government ought to be limited. And there's an argument that's gotten some support from places like the OECD, for example, that the debarment remedy is used too little in foreign bribery cases. And this connects to the discussion of settlement, because the criticism of settlement, maintains that prosecutors, when they're staring in the face the possibility of debarring a company, which would everyone, even people who think debarment should be used more often, would agree has significant collateral consequences for innocent third parties, including the company's employees and the government that may rely on that supplier for important goods or services. Prosecutors will be too unwilling to actually insist on debarment, and that companies will not agree to any settlement that includes debarment. But that as a result, companies know that debarment is never really on the table, because they know that if they commit the offense and get caught, the case will be resolved by settlement, and no matter what the law formally allows for, the prosecutors will not insist on a settlement that has debarment as a remedy. And therefore, because that's not on the table, debarment does not have a sufficient deterrent effect. So in my opening remarks, I had these two issues separate, but I think they're both naturally invited by several of your comments, especially, Luana, yours, suggesting that fines are not enough. So perhaps we should, again, if people have more general comments about settlement, I want to make sure we get to those as well. But let's just introduce these two ideas to the conversation, and I would love, as I said before, to have you all consider these issues in the Brazilian context about the appropriate role of individual versus corporate liability, as well as the appropriate use of debarment. So I want to get to you in a second, but I know there's a gentleman in the back who was waiting to speak before, so let me get your comment, and then I'll come to you on the debarment issue.
Thank you, Professor. I'm Victor Hugo. I'm an auditor at the Federal Court of Accounts in Brazil. I'm a civil engineer. I'm not a lawyer, neither a judge, but at the Federal Court of Accounts, we have some auditors specialized in public works. So as the car wash investigation had involved several construction companies, and we have audited several of the public works and the public contracts that were awarded to these companies. We have had some information and some knowledge about the case. So the problem is there was some facts involving a cartel as a bid rigging. The companies were rigging the bids at Petrobras, and the real sanction that they fear is the debarment. That's the point. But there is another problem about the settlements. As in Brazil, we have several agencies. We have the same or like the same tasks or missions and in an anti-corruption theme, and they have different levels of information about those that object or those facts. So in the Federal Court of Accounts, we have had audits since 2008 or 2007 about the contracts, and we have achieved some ways to calculate the overcharge the companies have achieved in the procedure of rigging the bids. But this overcharge was not included in the settlement. So the benefits of the corrupt facts were not included in the settlement. So there was this controversy in the settlement, as they could be too lenient or too aggressive, and depending in the way you may see the point, the question. So that's the point. The real stick we have is the debarment. That's the point we could see. As the companies that did not settle their cases, they were debarred, and they are likely to go bankrupt and as we say in Brazil, to die. But that's the point. We have different agencies. We have a complex institutional framework with the same tasks in this point. We have something like a commission, like a Federal Trade Commission, which deals with the point of rigging the bids, of these things about the competition in the market. We have the Federal Court of Accounts, which likes to audit the contracts and the payments about those contracts. And we have the public prosecutors. You see, that it's very complex, the case.
Certainly complicated. I know you've been waiting patiently to say something about the debarment point, so let me come to you now.
Well, this anti-corruption movement seems pretty similar to me to the fight against slavery trade in the beginning of 19th century, led by England, which was certainly it has some sense of human dignity, but it was important, but certainly not the main reason that justified this movement. And so in the case of fight against corruption, we have the United States ahead and all this movement that we are also dealing with in Brazil. But this permanent restriction on applying the debarment as a sanction in the United States can be interpreted as an economic movement to form and also protect national champions. And it also happens in Brazil with Odebrecht and other corporations, JBS. I think basically on these two corporations. And more recently, some political scientists contested this movement, saying that it's necessary, but certainly not justifying only on doing the right thing. But it has something behind it, and it's an economic movement. So I'd like to ask you, it's a more generic question, but I'd like to ask you how to deal with this perspective that anti-corruption wave is sometimes considered a kind of an economic movement and a political-oriented movement, and also if a focus on individual responsibility would not be a way out of this criticism.
I'm not sure I can fully answer that question. In some ways, I'm not sure I completely grasp all of the nuances of the question, so we might need to have a longer conversation maybe after the session. But I do think the question that you put on the table about the use of the debarment and the use of individual sanctions is really what I'm getting at and what I'm interested in discussing. I mean, one way one could frame the point, maybe to make it a little bit sharper, is I'd be interested in whether people think that, for example, Brazil, which I gather now has a mechanism that permits settlement, at least in some cases, though perhaps more limited in the United States, should eliminate that and require the prosecutors, when they have evidence that a corporation or its agents or officers have engaged in significant acts of corruption, to both prosecute the individuals and seek to debar the company. Right? So I mean, this is really the policy question. Is it better to give prosecutors the flexibility to negotiate a resolution of the issue that does not result in debarment and may or may not result in individual prosecutions, but doesn't necessarily? Or should prosecutors not have that option, such that if they want to hold a company whose employees have engaged in corruption accountable, their only option is to bring a prosecution action in court, the consequence of which, if successful, would be the debarment of the company? And I think that's the way to frame the question. And I have my own views on this, at least in the U.S. context. I'd be interested in what you all think. I mean, especially those of you who have expressed sympathy with the view that existing deterrence is insufficient and that we should see more things like debarment. Again, if you want increased deterrence, there are other ways you could try to do it. You could increase the fines, for example. You should say we still shouldn't debar the companies. They're still doing something valuable. There'll still be a lot of collateral damage to innocent parties if we wipe the companies out, but we should triple the fines. But there are others who might suggest, and Luana's remark, whether or not this is what she meant, I don't want to put words in her mouth, there are others who think that even if you raise the fine substantially, it still wouldn't have the deterrent effect of debarment, and because you're never going to get debarment if prosecutors have the authority to settle, because companies will never agree to a settlement that includes debarment and prosecutors will always back off, you have to take away from prosecutors the ability to settle these cases if you want debarment to be on the table. So what do people think on that policy question? Should prosecutors have the flexibility to reach a settlement that allows a company, including a national champion, to avoid debarment? Or should prosecutors be prohibited from settling those cases, at least if settlement includes no debarment, and they should have to bring the case? Is that a hand or is that, yeah, great.
Good morning. I'm Marcelo Pontes. I'm from the government of Federal District, from the Civil House. And, well, my question is, in fact, trying to add a new point to this discussion. Is the fact that in Brazil we have not regulated, as far as I know, bribery among... Is not working? Okay, again. Marcelo Pontes from the government of this Federal District. I am an electrical engineer, just like my colleague behind. And, I want to add a point here. In Brazil, as far as I know, bribery among corporations is not regulated. So I would like to know if this fact here in Brazil can compromise the outcome of settlements. As here, it's not a crime if a company pay bribes to another company in order to achieve some kind of agreement. That's my point here.
He has a question, and he's going to speak in Portuguese, and then I'll try to translate for you, okay? I'll try.
Okay.
Is this? I think both our mics are now out.
Bom dia a todos. Eu não vou arriscar fazer a pergunta em inglês, embora conheça a língua. Utilizando a língua nossa aqui, o vernáculo, né? A questão que se fala sobre o acordo de leniência aqui no Brasil, refere-se ao acordo administrativo, né? Normalmente, o acordo penal ele se circunscreve à delação premiada. E hoje o novo governo, através do ministro da Justiça, que vem, inclusive, conhecido no nosso meio jurídico, que é o juiz federal, né? O Sérgio Moro, já anunciou, embora não tenha ainda deixado claro o texto, que fará uma proposta de plea bargaining. Então, essa proposta de plea bargaining me parece que ela fecha o sistema e é a principal diferença que existe entre o sistema americano e o brasileiro. Então, nessa forma de agilidade e de transmitir a segurança jurídica necessária e ainda a punição correspondente a isso, né, que precisa, talvez essa forma esse projeto, que é um projeto estranho à nossa legislação, né, mas que a ideia é que seja introduzida como independentemente de reforma constitucional, através de lei ordinária. Essa é a pergunta que eu faço ao professor, se ele acha que essa questão ela é fundamental no aperfeiçoamento do nosso sistema, né, e no combate à corrupção, nesses crimes de corrupção.
He says that in Brazil, the settlements and the leniency is only about administrative procedures and civil liability. And what is your opinion on NPA agreements on criminal liability, criminal law? And he remembers that this is being discussed on the federal government. This is in the political agenda right now. And he asks you if you think this is something that can enhance the anti-corruption system. What do you think about the plea bargain?
I mean, all right, so let me address this first, then we'll get back to the topic we were talking about a moment ago. As I alluded to in my opening remarks, there are a lot of advantages to settlement in criminal cases. I was talking previously about DPAs and NPAs, which are distinct from plea bargains in that, at least as that terminology is used in the United States, a plea bargain involves the defendant pleading guilty to the crime. So they would have a criminal conviction on their record, and then paying some kind of penalty, usually a lesser penalty than they might have been subjected to if they had gone to trial. Whereas a DPA, NPA does not involve the company actually pleading guilty, even though there is an acknowledgement of wrongdoing. In the United States, the overwhelming number of criminal cases settle through one of these mechanisms. Traditionally, it's been plea bargaining. We've seen the rise of the DPA and NPA mechanism, especially in the corporate criminal context, in the last 15 or 20 years. I can give a response to this in the US context better than I can for the Brazilian context. In the US context, I'm favorably disposed in broad terms towards the existence of plea bargaining as a mechanism, though I recognize that it has problems, and the reasons are similar to the ones that I offered in my opening remarks. From the perspective both of the government and of the criminal defendant, going to trial is risky and costly, and both parties could be made better off, at least from a forward-looking perspective, if they reach an agreement that is more favorable to both of them than the costs and risks of going to trial. And plea bargaining does give prosecutors substantially more leverage. Now, the greater leverage the plea bargaining system gives to prosecutors actually gives me some concern about how the system is used in the United States for what we might call street crime or lower level crime committed by individuals. Very often in those contexts, prosecutors have so much leverage that what they can threaten individual defendants is so severe that I'm more sympathetic to the argument that prosecutors are able to use the plea bargaining system to impose penalties on a very large number of defendants where the prosecutors would be much more constrained if they had to go to trial. My own personal views are that in the white-collar corporate context, things are different. In that context, I am less concerned about prosecutorial overreaching and more concerned about prosecutors being overly constrained when they face a large number of extremely affluent defendants. And so in that context, I'm even more favorably disposed towards plea bargaining or DPAs, NPAs, which for purposes of your question, I think we can treat as basically the same. So I guess what I would say is on the whole, I'm favorably disposed towards the settlement. Again, for purposes of this conversation, though, I'm not here so much to push my own views as much as I am to spark this conversation, especially because, as I said just a moment ago, I'm more confident making that statement in favor of settlement in the context of U.S. FCPA enforcement than I am in the context of Brazil, because I recognize that the background conditions might be sufficiently different, that a system that works well in the United States might not work as well in the Brazilian context. And my purpose here in the limited time that we have is to provoke more of that conversation. The point about corporations bribing other corporations, I will treat the way I often have to respond when, as a professor, some student in class raises a really good point that's kind of not the point we're talking about, which is to say, that's a really good point, but that's not the one we're talking about, so to be continued. But I see some other hands over here, and since we've been over on this side of the room for a while, let me zip on over here, and then you, ma'am, and then you.
I'd like to touch upon the difference between backgrounds and cultures and legal cultures, because I think that's very central to the implementation of a settlement system in Brazil, because we are trying to adapt something that's coming primarily from the US, but we don't consider that in the US we have this long-term culture of plea bargain at the individual level, so plea deals and guilty pleas, and we're trying to implement that in Brazil at the corporate level, but I think we should take a step back first, because we don't have the stick. I mean, the rules about corporate liability are not that clear as they are in the U.S. So there's this difference, and also because companies don't fear the penalties that cannot be imposed to them, and they also don't see how beneficial a plea agreement could be, because we don't really use this in the individual level. So going back to the policy matter that you asked before, if we should allow prosecutors to offer agreements, I think that it's very important that we do, but in a different time, maybe in the near future. But for now, I think it's important to establish that companies can be held accountable and that they will face penalties that are not only financial, they're not only fines. And I think that once we establish that as a reality in Brazil, we can then move forward to offering agreements by prosecutors or, I don't know the level of judges' involvement, but I think that should be something for the future, that if we try to implement this at this moment right now, it's not going to be effective and may very well serve as a very short-term solution that will only mask the problem.
Hi, good morning. My name is Maria Cândida. I'm a federal judge. So the point I'd like to make is that I think the anti-corruption culture in Brazil is still evolving a lot. I think that the case we had against Petrobras, people really got it, you know, because Petrobras, it was a government company, so they really got what was going on. But when the case, car wash, went against private corporations, and I think that's the big breakthrough there, because you have on the one side public officers, and the other side you have private corporations. And I think that culturally speaking, people understood a little bit of this, what you mentioned yesterday, the self-reinforcing culture, because these senior members of these corporations, they said, we had no choice. You know, we were in Brazil. If we wanted to make business in Brazil, you have to do that. So we had no other choice. So I think that's why maybe they don't really get the consequences of reputational damage in Brazil, because still in this moment, I think you wouldn't maybe be affected by consumers' preferences. Consumers would get, this is what was going on. So I think that, for instance, now we had a newer case against JBS. Now it's different because all the corruption they made was going against consumers. This was a case that they were making a bypass on all regulatory regulation on meat. So actually, it's something that it will affect consumers' health. So maybe now we're evolving a little bit on that. So I don't think we're in that point like in Europe, for instance. You know, if you hear that a company is really acting in bad ways, people would say, oh no, we're not supporting that company. I'm not buying these products. And then it would be the end of the company. So I think in Brazil, it's our next step, you know, to really face corporate liability. That's all.
Oh, yeah, please. And then.
I'm just gonna compliment a little bit of what she said, because here in Brazil, this is a little controversial, but I think this point should be raised, is that in here, many times, corruption is on both sides. It is in the state side and also in the corporation side. So when people are trying to investigate, they face barriers that come from political agents, because, as I said, many times it is within the state, and honest people who are trying to investigate, they can't do it because there is political influence. So I would just like to ask if this is in America too, if you have that feeling that sometimes it's really hard to cross that barrier of political power. And this is part of our culture also. I mean, our ex-president is in jail. So.
Because of time, I can't give you a full answer to that question, except to say in brief, not nearly to the same extent. I won't say that there aren't cases in the United States where the background political context may lead to pressure or difficulties with investigations, especially we have a special counsel investigating our president and people very close to him right now. But those are quite exceptional circumstances, at least at the federal level. At the state level, things may be a little bit different and less good. At the federal level, I think that is an important difference. It's not entirely clear to me what significance, if any, that has for the debate about whether Brazil's federal prosecutors should be allowed to negotiate settlements with corporate defendants or whether they shouldn't. But I think that's certainly an interesting issue to think about, because as you rightly point out, the contexts are different.
My name is Marlon. I'm a federal judge and SJG candidate at American University in Washington. My point is adding her point, because the last 3 years I have researched about plea bargaining and NPAs and how to incorporate them in Brazil, and if it's possible. So, and one thing that I realized is about the misinterpretation how things are going on in the US. For example, recently the National Council of the Public Prosecution in Brazil released a resolution trying to regulate in Brazil the NPAs. First, at least in my opinion, this was wrong because the Constitution says, okay, only the Congress may enact criminal procedure and criminal law statutes and legislation. So this is the first point. But the second point is the main target of this resolution was people who commit crimes up to 4 years in prison. So automatically excludes corruptions and other things. So instead of trying to targeting the things that real harm the Brazilian society, we are not trying to do that. So in my opinion, this is the first misinterpretation about how things are going on in the US. And the second point is we already have a bill in the Congress trying to enact a new criminal procedure code enacting plea bargaining in Brazil. But again, only for crimes up to 8 years in prison. That excludes corruption as well. So we are trying to figure out how to do it, but in my opinion, we are trying to figure out how to do it wrongly. This is just a point to add in her question.
Well, terrific. There's so much more we could say on this topic, and I do hope the conversation continues, but I pledged the organizers that I would end this session exactly on time, and we are at our time. It is now noon. So I won't try to attempt any big wrap-up again because there's so many complicated issues, except to say that I do think this is a sufficiently important issue about the design of institutions and about prosecutorial strategy that it deserves a lot more attention. And as you say, it's a nice point on which to conclude. Really careful attention to the context and the specific laws and how they operate is very important. I do think, maybe I will say just one word by way of conclusion, especially since there are so many prosecutors in the room, a lot of the way the US system of settlement functions presumes good faith in prosecutors, that prosecutors will be, they won't always be perfect, but that you can basically trust them, that you can empower them with this kind of legal leverage and then rely on them rather than the courts to be the ultimate determiners of what's the right way to resolve these issues, of course with the courts sitting in the background. There may be variation across countries about how much we're willing to empower prosecutors in that way. That point complements a second point that several of you have brought up, which is that you're not really empowering prosecutors to take on that role if you don't have the threat looming in the background of very serious consequences on corporations who are not willing to settle these cases for significant amounts. So one of maybe to combine the points, maybe a way to think about the crucial choice that countries are making is, do we want to create a system in which we give prosecutors a great deal of leverage and then trust them to use that leverage in an appropriate fashion, perhaps with some degree of judicial oversight or regulation, a topic that, as I said in my opening remarks, is an important topic of international discussion and some disagreement that we didn't really get into depth today. So I lied to the organizers, we're ending 1 minute late, but I hope that doesn't set us back too much. Thank you very much. I look forward to seeing, I hope, most of you, all of you, tomorrow as we continue. Please do the readings if you haven't yet, and I look forward to another stimulating conversation along similar lines to the way we ran the session this morning. See you all then. Thank you for getting it going. I have no sense of whether this is